everyone. A very warm welcome to all the participants joining us today for a session on criminal law. Before we formally begin, let me ask you a question. So, whenever we hear about the term criminal law, we often think about courtrooms, police investigations, arrest, or criminal trials. But have you ever wondered what actually happens behind the scene? What role does a criminal lawyer play in a criminal trial? Today's session is designed to answer all of those questions. Today's session is organized by the Collective Council, a platform dedicated to bridging the gap between legal education and legal practice. Through our initiatives, we strive to provide practical learning opportunities, mentorship from experienced legal professionals, skill based training, and opportunities, career oriented legal education. Our objective is simple to help law students and young legal professions develop practical legal skills and prepare them for a successful law career. It is now my privilege to introduce our esteemed speaker for today's session, Advocate Raghav Puranik sir. Advocate Raghav Puranik sir is a respected legal professional with extensive experience in criminal law and litigation. His practical experience, courtroom exposure, and commitment to mentoring aspiring lawyers makes him the ideal person to guide us through today's session. On behalf of the Collective Council, I extend a very warm welcome to you, sir. And without further delay, I invite Advocate Raghav Puranik, sir, to take over the session. Before we begin, I request everyone to kindly switch on their cameras so it's an interactive session. Over to you, sir.
Good evening to one and all. First of all, I'm happy to see that on a Saturday evening, you guys have taken out time to listen to me on the aspects of criminal law. I can see even some of my students whom I've taught previously at ILS. So it makes me feel happy that I'm here to share with you my thoughts. Coming straight away to the topic, because the topic is huge and extensive. I'll try my best to complete or share with you all that I've learned over these years at the court within the time frame that has been allotted to me. So considering this topic, initially let us start with, it says Master Criminal Law Fundamentals. As I always like to say that I am a student of law, and every lawyer is a lifelong student of law until the end. So I don't think I'll be able to tell you everything such as we will be masters, but we can definitely be good students of law. And today's session will be an endeavor in being good students of law from here on. So the first thing that I intend to tell you guys all about is, when we come to a criminal trial, we know the basic elements: the registration of FIR, the filing of charge sheet, then thereafter there is framing of charge. But how do you deal with the aspect of BNS? A criminal trial is always a combination of three laws: the BNS, the Bharatiya Sakshya Adhiniyam, which was earlier the evidence law, and the BNSS, that is the procedural law that is involved when you are dealing with a criminal trial. We will come to the more practical aspects, but let's start with BNS. The first thing that a lawyer needs to do or understand is that he needs to understand the breaking of ingredients. He should understand that when a particular section is leveled against his client or the accused person, how he is going to break down those particular sections. For example, let us consider an offense of cheating. Cheating has many elements. The first element is that there must be a dishonest or a fraudulent intention. Secondly, there must be inducement of the person who is affected or who is the victim. Third, there must be a wrongful loss or a wrongful gain caused to the person who has caused that cheating. If all these elements are satisfied, then and only then you can say that the offense of cheating is made out. So a lawyer's job is to see whether all these elements are being satisfied. He has to put forth the facts before the court of law that such and such elements are not being satisfied, and that is why an offense of cheating is not being made out. These days you will see a common rise in cases wherein a person, he is initially good at share market, he starts making certain good amount of profits, then his relatives or friends comes to know that he's good at share market. They say that, okay, we will invest such and such amount of money with you, and you do share market trading for us and give us such and such returns. Okay, a promise is made, an element is fulfilled, that this promise is there. But initially, he does not have any kind of intention, or at inception of this transaction, he does not have any kind of intention to cheat those people. Unfortunately, he suffers a loss in the share market. He is unable to return that money. And then FIR gets filed under section 420. Now it is section 318 under BNS, earlier 420. So at such point of time, as a lawyer, your job is to see whether an offense of cheating is made out, whether there was a fraudulent intention right at the inception of transaction, such that the prosecution can say that yes, there was a fraudulent intention and there was an inducement. Second thing you should understand is this: how sections differ. For example, in lot of FIRs, okay, I'll try to incorporate both languages. In a lot of FIRs, you will find that there is two sections which is leveled. 406, earlier 406, now it is section 316, and 420, now it is section 318. So 406 or 316 is criminal breach of trust, and 318 is cheating. You will find a lot of FIRs. Now, if you see the case laws right from 2002, starting from SW Panlitkar to the latest one in 2025, which is Delhi Race Club versus State of UP, multiple times Supreme Court has stated that a criminal breach of trust and cheating cannot occur at the same time. As a lawyer, you must be able to figure that out. Now, when you go to the High Court level, you can get the case quashed, but at a trial court level, there is no such provision for getting the case quashed. So you should be able to figure out that how entrustment is different from inducement. Inducement अलग होता है, entrustment अलग होता है. अगर entrustment है, तो inducement नहीं होगा. So existence of 316 results into the negation of existence of 420. So as a lawyer, you should figure out that whether 420 is applicable in this case or 316, whether criminal breach of trust or there is an element of inducement. Inducement क्या होता है? When a person says that I have a good scheme, if you give me certain amount of money, I'll invest that money in that scheme, you will get the double of that. You must have watched Fir Hera Feri, 21 दिन में पैसा double. That is what is inducement. That is what leads to cheating. But few days back, 2 days ago, I was at the jail. I was supposed to go and meet a prisoner inside. So there, no electronic devices are allowed. A colleague of mine was there with me. So I handed over my mobile. At that point of time, I had entrusted my mobile to him. If he runs away and he sells off that mobile, at that time he has performed a criminal breach of trust. He did not induce me. उसने ऐसा नहीं बोला कि आपका मोबाइल मेरे पास में देके जाओ और मैं इसका ख्याल रखूंगा. That would have been an inducement. I had entrusted something by my own volition to that particular person. And that is the difference between criminal breach of trust and cheating. So as a lawyer, you must understand what is the significant difference. And that is why I started off this session by talking about the ingredients. When you understand each and every ingredient and you understand how to break those ingredients, you start to understand how you are going to face that particular case. The second aspect is, once you understand this aspect, you need to also move ahead in a criminal trial, and right at the inception, you should know how much of the case you are going to admit. For example, now many lawyers have different ways of dealing with these things. Some lawyers outright go and admit everything. Some lawyers try to withhold. For example, let's consider a case of abetment to suicide. We had dealt with such kind of a case. This person, yes, for inducement 420 applies, 318 now, and for entrustment 316. Now coming to the aspect of this, of admitting or not admitting everything, consider a case of abetment to suicide. This person was married to a particular lady. This lady was the accused in this case. The man was the deceased man. He did not wish to get married to that particular lady, but due to family pressure, he had to marry that lady. So from day one, right itself, from day one, he was in love with some another woman. The family did not allow that marriage to happen. So from day one, there were problems in the marriage. At the same time, he left his job. He wanted to pursue a restaurant business. He opened the restaurant. He took loans for that, but the business tanked. He suffered a huge financial loss. He had borrowed some money from friends. those friends started asking for money, because of which the friendship soared. So he was facing disappointment on every part of his life. So one day he went to have a party at his friend's house. They were drinking while they were sitting in the balcony of that particular house. His friend wanted to use the washroom, so he went inside the washroom. As he came out, his case, the prosecution's case was that as I came out, I saw him fall down from the balcony. Now, an FIR was registered, a case was registered for abetment to suicide. The complaint, the deceased father was saying that it was due to the domestic problems, and because of the problems created by the wife of this person committed suicide. So she became the accused person in this particular case. What are the documents? The major documents in this case is the FIR. Then comes the spot Panchanama, that is the Panchanama of the occurrence. Then comes the inquest Panchanama, which is done right at that particular spot. Then comes the postmortem report. And finally, the statements of all the witnesses. This will form a major part of the charge sheet. There are two ways to deal with it. As a lawyer, you have to decide at such point of time how much of the case you are going to admit. Some lawyers will admit everything. Now, you must have studied evidence law. Evidence law says facts, everything that has been admitted need not be proved. So if you admit spot Panchanama, some lawyers will say, okay, we admit the suicide. So what they will do, they will not conduct any cross-examination for spot Panchanama. They will not conduct any cross-examination for the doctor who has done the postmortem. They will admit everything. They will admit the suicide also. Their final argument and their cross-examination will only be based on the fact that yes, he did commit a suicide, but there were other reasons, such as his financial loss, his soaring of relationship with his friends, his family members going against him and getting him married to some other woman. But it was not the accused who was the sole reason. The second way to go about this same case is the defense of complete denial. You deny the suicide. You read the spot Panchanama carefully. You see the height of the railing of that particular balcony, and you argue before the court and you bring in before the court that this was a case of accident. He was drunk. He was not in the right senses. He fell down from the particular balcony, and this is a case of accident and not a case of suicide. So as a lawyer, you have to decide how much of the case you are going to admit. And you can do that only when you know the ingredients clearly. You should know what is abetment. You should know what is abetment to suicide. Which of the ingredients shall be fulfilled. And then you have to work around in that particular case. The second example I can give, which is very common, is of the cases of rape and sexual assault. Rape on the false pretext of marriage are the most common cases that you will see in the court. Most of the times, in the court itself, right at the stage of bail, you can see a lot of lawyers admitting that, yes, we were in a relationship. The boy and girl are usually in a relationship in such case. There is consensual sexual intercourse. But later on, due to some reason, if the boy does not marry that particular woman, that woman files a case for a rape. Most of the lawyers, right at the beginning, right at the stage of bail, admit to the fact of consensual intercourse, which in my humble opinion is not the right thing to do. Because the moment you admit consensual sexual intercourse, you have admitted the 50% case of the prosecution. You have admitted that particular act. So what is going to happen is that you are making the job of the prosecution easy, and you are taking a more larger burden upon yourself to show to the court that it was consensual. What you do in certain cases is you go into the mode of total denial of any kind of sexual intercourse. Let the prosecution prove. Let the prosecution examine the medical witnesses. In such cases, there are no eyewitnesses. Everything happens in an enclosed space. So let the prosecution prove through doctors and through other evidences, yet, yes, there was a sexual intercourse. You go into complete denial, you bring in, and in such kind of cases, I'll tell you, there are always certain other factors. Sometimes they are working at a common workplace. That person is the boss of that woman. He has promised some promotion, but he does not give that promotion. So she goes and files a rape case. So you have to search for such ancillary reasons of why the case has been filed against you and why the woman who had given consent earlier now says that there was no consent. So that is why you should not admit the total case. Similarly, you will see the same case happening in hit and run cases also. The cases of accident, you never admit the dash. The moment you admit that your vehicle has dashed with the other vehicle, you have admitted 50% of the case of the prosecution. Of course, it depends from lawyer to lawyer. Most of the lawyers admit all of these things, and they are so confident that in cross-examination, I'll break down the witness in such a way that all will come on record. But it is my personal opinion that you have to think of it in that way, in which case you admit everything, in which case you go into the mode of total denial. When you come to criminal law, you must also understand the distinction between what is intention, what is knowledge, and what is negligence. A lot of times, when I teach even in law school, a lot of law students and even initial level lawyers, junior lawyers, often mistake in between all these things. I often give this example of that Porsche car case, the accident. Of course, an unfortunate incident. But what we must understand, how we lawyers must be different from the layman, is that when a person sits in a car, he's not driving the car with the intention of killing those two individuals. Intention is different, negligence is different. At most, you can say that the person was negligent in that particular case, but you must not confuse it with intention, and you will see such cases. Recently, we have a case wherein a vice president of a big construction company has been arrested. What are the facts of this case? That this construction company had given two contracts. Some work was going on the 6th floor and some work was going on the ground floor. Certain stones were kept on the 6th floor. Out of that, one stone fell down and it landed upon a worker who was working on the ground floor. Even the vice president of that company has been arrested. And what is the section? The section is of murder. Now, as a lawyer, you must put forth these facts in front of the court, that when it would have been a murder, suppose I am the vice president, I have come for the inspection of that site. Maybe he's a security guard. He did not salute me. My ego was hurt. What did I do? I took a stone, I threw it from the 6th floor, it landed on his head. That time you can say that there was intention. Secondly, I am the one who is the contractor who is responsible for carrying out the work. I have kept those stones on the 6th floor. I have knowledge that this is dangerous. Plus, there is no protective net. If you see the construction buildings, there are protective nets on the top floor for preventing such kind of incidents. So I, as a contractor, has not taken the care. I have the knowledge that there is no protective net. Still, I have instructed that the stones be kept on the 6th floor on the edge. Then they can say that yes, there is an element of there is an element of knowledge. He had the knowledge that if this stone falls, and he should also have the knowledge that person was working below. If he does not have the knowledge, then it goes into the realm of negligence. Suppose I am someone who is the contractor's son. I am a major. I have gone with the contractor to look how the construction is being constructed. I let my intrusive thoughts win. I see अगर मैंने ये पत्थर को लात मारा तो ये नीचे जाके कितना अच्छे से गिरेगा. I kick the stone. That unfortunately it lands upon that worker's head. That time you can say it is negligence. So as a lawyer, you must also figure out which case comes under intention, which case comes under knowledge, and which case is coming under negligence. You have to figure all these three things out, and then you have to go into figuring out how you are going to go about that particular case. One another aspect which comes up now, maybe I'm going too fast because I want to convert or touch upon all these aspects. We'll all definitely have a dedicated question and answer session. Sometimes also forgive me for the fact that I am a lawyer and we are more accustomed to argue before a court of law. So a judge is always accustomed with these facts. Maybe some of your students, this is being too fast, but in questions and answer sessions, I'll try to answer all of those things. But I want to cover and give you an idea of each and every aspect. That is why I'm covering it in such a manner. Once you are done with intention, knowledge, and negligence, let's come to one more aspect which is involved in a lot of cases. You will see that aspect being involved in this latest case also of that Lower Fort, which is being discussed on a greater level in the social media or in the newspapers. The aspect is of common intention, common object, and criminal conspiracy. Now, what is the most difficult part? Now that case is sub judice, the Lower Fort case. What is the most difficult part for the prosecutors or the prosecution in this case is of the criminal conspiracy, proving that the boyfriend, the alleged boyfriend of that girl, and that girl had a criminal conspiracy to murder that particular deceased person. Because conspiracy, you will find there is often no direct evidence. I'll tell you how later on how that becomes relevant. But let's first see the difference between common intention, common object, and criminal conspiracy. Common intention, if you go and see the wordings, section 3, subsection 5, it says in furtherance of common intention. Suppose A and B want to murder C. What does B do? B catches hold of that person C, and A does the work of stabbing. They have both of them worked in furtherance of common intention. At that time, 3 subsection 5 becomes applicable. At that time, you can say each person, when he performs an act, then he becomes liable for common intention. Suppose they are doing a bank robbery, 3 people. One is driving the car, one goes inside, threatens the people, third one takes out the money, fourth one drives them away. All of these people have performed a act with common intention. Now let's come to common object. I always like to cite the example of the movie Singham. When we are talking about common object, you must have seen that movie. In that movie, when that Jaikant Shikre comes to that Ajay Devgan's police station for signing of that bail condition, he has to go and sign and mark his attendance. At that time, he threatens him, and all the people in that village gather over there. Ye hamare Singham ko dhamkata hai. And then one of them climbs on top of that Jaikant Shikre's car and he inserts a iron rod in his car. He has committed an offense at that point of time. The other people standing over there, and this happens in real life cases, 7 to 8 people go and they murder someone. One of them takes the defense that I did not have any weapon in my hand. I was just standing over there. Other people in that movie could have taken the defense that we were only standing over there. We did not attack that person. We did not land a blow upon that person. We were not holding a weapon. But I'll tell you over here, this is where common object becomes relevant. Earlier, section 149, any unlawful assembly, even though you were only present over there, can make you liable to that whatever offense is being committed, whether it is murder, whether it is attempt to murder, or whatever it is. Just by the fact that you were present over there, you will find numerous judgments of the Supreme Court where Supreme Court has convicted a person just on the basis of the fact that he was present over there at the time when the offense was being taken place. It does not matter what defense he takes. It does not matter that he says कि मैंने तो कभी उसको मारा ही नहीं. Since you were a part of that unlawful assembly, the moment it is proved that you were a part of that unlawful assembly, you have become liable under common object. That is why you find the word in the section in pursuance of that common object. Now coming to criminal conspiracy. How is a criminal conspiracy different from common object? In criminal conspiracy, there is an agreement. Agreement either to do an illegal act or an agreement to do something legal in an illegal way. Both of these become culpable under criminal conspiracy. What is important word? The important word is agreement. It does not mean that the person should commit that particular act. For example, I want to get someone in my competition murdered. I will hire 2-3 gangsters to do that job. They will go and murder that particular person. Okay? I cannot say that I did not perform any kind of act. I was not even present at that location. When the murder happened, I was sitting in my house. What will the police search for? Police will search for the evidence of agreement. If they find out at that particular point of time that I was in agreement with those 2 people, at that time I come under criminal conspiracy. This is what the investigators are trying to do in that Lower case. That is why on day 1, you have news coming in that the video was there that they had met in a cafe. What is the prosecution trying to do? A meeting of minds before that particular incident. That is why you have that video of cafe. But it is not enough. A good defense lawyer will say, maybe we were meeting the last time before that girl got married. We were still in touch because we were in love and my family was getting me married against my wishes. That is the first one. Second one, then you find another angle. They said that she took 1 crore rupees from that deceased and gave it to her alleged boyfriend. That 1 crore rupees is going to become further a element of conspiracy to show that there was a meeting of mind. Maybe 1 crore rupees वो सुपारी थी उसको मारने की. And the third aspect now, if I've read it correctly, I'm speaking all this on the basis of news reports that I've read and without meaning any kind of intention or imputation on any of the person involved in the case. The third is they are saying that they have caught hold of a person who knew of this particular plan and who had advised them not to commit a murder. He is the friend of that accused number 2, who is the boy in this particular case. What they will do, they will make him an approver. This is the standard operating procedure in any case of criminal conspiracy, because it is very difficult to find direct evidence of criminal conspiracy. Nowadays, technology has made it possible. Nowadays, you have the mobile phones. So what police does? Police gets the CDR that 2000 कॉल हुए थे, 1500 कॉल हुए थे, इंसिडेंट के पहले 10 कॉल हुए थे, but they cannot get the transcript of conversation. So what they do, they bring in witnesses कि हाँ मेरे दुकान में इनका मीटिंग हुआ था, तब उन मीटिंग में इन्होंने डिस्कस किया था कि ये इसका मर्डर करने वाले हैं. That is how witnesses are also planted. I am not saying that in every case they plant witnesses, but as a criminal lawyer, you must be absolutely aware that which can be the witness which can be planted. That is why you have the concept of chance witnesses in cases. Sometimes there is an accident. A person randomly appears and says, yes, मैंने accident देखा था. Then at the time of cross-examination, you have to ask them question that where do you reside? What is your place of job? What are your work timings? Then on the basis of that, you have to draw an inference कि अगर ये रहता था हड़पसर में, how he is at Law College Road, where the accident has taken place. फिर उसको पूछो तुम्हारा जॉब, अगर वो बोलेगा मेरा जॉब कोथुड़ में, तो ठीक है, शायद वो लॉ कॉलेज रोड से जा रहा होगा. बट अगर उसका जॉब हड़पसर से पर्वती है, देयर इज नो चांस. यू आस्क हिम द टाइमिंग ऑफ जॉब. अगर वो कहता है 8 से 5 मेरा जॉब का टाइमिंग रहता है, एक्सीडेंट हैज टेकन प्लेस एट 11 AM in the morning, then he must be present at his job. You have to draw such inferences. That is how you discredit a chance witness. This is done. Most of the times blood samples are taken. In murder cases, they take blood sample of the accused person. Now you have to be very careful in reading the charge sheet. When they take those particular blood samples, suppose they are taking 5 vials, you always have to see, most of the lawyers, they do not read the letters. Okay, they have taken the 5 blood samples. That blood sample may be while stabbing that particular person, that person also attacked on the accused person. He was bleeding. His blood is on the shirt of the deceased person. So to confirm that it is your blood only, if you are the accused person, they will take your blood sample and they will match the blood on the shirt with your original blood sample. Sometimes there is no blood anywhere. So what they do, they take the knife, and these are from real cases. If there are 5 vials of blood, you have to ensure कि 5 के 5 vials ही forensic को जा रहे हैं, जाते 4 vials है. 5th vial कहाँ जाता है? That goes upon the shirt. The 5th vial goes upon the knife. Sometimes when the muddemal is opened at the time of cross-examination in the court, you find they say that knife from which the murder was committed, that knife is brand new knife. That knife does not have any kind of blood markings upon it. So you have to bring such facts to the notice of the court. Sometimes you do it through cross-examination. Sometimes when they open it, you as a lawyer casually make a comment which can be heard by the judge. अरे ये तो नया दिख रहा है. That is how you influence, because at the end of the day, the judge is also human. That is how you bring things to the forefront. So you should know what are the type of offenses, what is the distinction in the offenses, how those offenses are, whether they are applicable or not. One thing you also have to do is you have to identify the roles of the people who are involved. Identification of roles is very important, because someone might have stabbed him, someone might have procured the weapon, someone might have given the money for procuring the weapon, someone might have provided a car to run away from the place of incident. So this identification of roles is very important. Like one of the cases that I'm dealing with right now, therein they have invoked section 79 of BNS, which is saying words, acts or gestures which can be heard by the woman, which will outrage the modesty. There are 2 accused persons. Now one accused person, maybe he has uttered certain words, but the second person has spoken upon the religion of that particular woman. He has made religious comments upon that particular woman, which has no connection at all with the offense which has been leveled upon them. So in such cases, it is the right course of way to apply for a discharge application right at the beginning. for that accused number 2? Why to let him face the entire trial, get him out right at the beginning? Because the section itself is not being made out against that particular person. So you will also see such kind of cases wherein there is no application of that particular offense, and that is why you have to be more careful as a lawyer. After that, you should also know, like, there are certain offenses like forgery. Forgery is a very complicated offense under BNS. Forgeries of different types: creating of a false document, showing a false document to be true, or showing a false document to be a real document, doing a or getting a document or creating a new document showing it that this is an original document. I'll give you a small example. When you guys maybe were in school, sometimes you had a bad result. If you read the section of making a false document, what you used to do, you used to sign yourself in front instead of your parents. At that time, you have made a false document. Sometimes it is your parent who is required to sign. You are not signing yourself, but you are telling your elder sibling to sign on that particular thing. At that time also, you have made a false document. Without a person not having authority to sign something, has made a sign upon that, or he has affixed a stamp upon that. At that time also, a false document is being made. When making of such false document is combined with a fraudulent intention, you enter the territory of forgery. So that is why BNS is very important to understand. It is often very neglected in all these procedural laws and everything. So that is why study the whatever the roles are there, you have to study them very clearly. Now coming to the more practical aspects. When the charge sheet is filed, there are 2-3 practical tips that I wish to share with all of you. First thing is that when the charge sheet is filed, I see a lot of lawyers, they reveal their entire defense right. I'll come to in the question answer. I can see Ritesh wants to ask some questions. In the question answer session, I'll complete all those questions. I just wish to get these points through first. Most of the times, what happens is most of the lawyers, right at the time of bail, they give out their entire defense, which I suggest not to do so. Because this giving out entire defense, you should also understand that when a accused person is arrested, in the first 15 days, you are dealing with only the police custody or the judicial custody. The charge sheet is not filed until 60 days or 90 days, depending upon the nature of the offense. So what you do is most of the times, and this has become a new trend, even in media, once the remand is done, they come out before the media, they reveal their entire defense, which is something that I advise against, because the prosecution is still working, and based on your defense at that point of time, they fill up their loopholes while filing the charge sheet. So at the bail, you have to be very conscious how much of your defense you are going to reveal at that particular point of time, and how much of your defense you are going to reserve from the point of view of trial. There are also certain aspects where lawyers get confused. Now, it is a very common and established principle of criminal law that a prosecution has to prove its case beyond a reasonable doubt. Now, what most of the lawyers end up thinking is the entire burden is lying upon the prosecution. It is often said that the accused can remain silent during the entire trial and he can still be acquitted. But that happens only in cases where all the witnesses have turned hostile, or the witnesses, even if they have not turned hostile, they are not saying anything which is inculpatory to you, or they have not touched the ingredients of the offense. That does not happen in cases where the witnesses are speaking against the accused person. So even if there is a fundamental principle that the prosecution has to prove a case beyond a reasonable doubt, it is also the duty of the defense counsel to explain the inculpatory circumstances. For example, if you are present at the spot of the murder, why you were present at that point of time, that duty lies upon you. You cannot neglect that aspect completely. The moment the prosecution, for example, let's take this as an example, maybe there is some protest which is going on in a government office. The probable section will be of unlawful assembly and everything, and section 353 earlier, which was deterring a public servant from performing his duty. You are one of the accused persons amongst the 25-26 people that were involved, but you were not involved in the process, in the protest. But the CCTV camera is showing that you are standing near the location where these people were protesting. These are real life cases where such things happen. Defense counsel, you have to explain why you were present at that particular location. You have to explain the actions taken in the Department of Education. So, what is the probable defense? If you are a student, you say, I was a student who had gone there for an official work. Since they were protesting, I was just watching, but now they have included me as an accused person. This is the explanation that you give. So, if you are present at a particular spot where the offenses occurred and you are one of the accused persons, you have to give explanation of why such and such thing has happened. Why are the witnesses speaking against you? Why are the witnesses? Because witnesses have no interest. If he is a completely unrelated witness, why will he falsely implicate you? So you have to tell the court that you are being falsely implicated and such is the reason. Also, you must also remember at this point of time that this explanation should not be something absolutely bizarre, which is not at all connected with the case. It must always be connected to that particular case in such a way that you can say that your theory is touching to the story of the prosecution. I always give this example of the Salman Khan case, wherein the witnesses are saying that we saw Salman Khan get down from the driver's seat. But see how beautiful explanation his lawyers had given. They had said that when he crashed into those people, his car went inside that particular laundry. He was not driving the car, he was sitting on the left side, on the passenger side. But since that passenger side was stuck inside the laundry, they tried getting him out from the passenger side. 10-15 minutes passed by, but ultimately they were unable to get him outside from that passenger side. That is why when the people gathered near the car, they saw him getting down from the driver's side because the other side was closed. This is how you explain the circumstances. That is also your duty, and that is why you have section 313. Earlier section 313, now it is section 351 under BNSS, that the accused is given a chance to come and explain the inculpatory circumstances, why these people are implicating you falsely, why these people are deposing against you, why these witnesses are telling everything against you. So if this is a false explanation, you have to examine yourself, and that is why no oath is administered to the accused. When he is being examined on such a level, no oath is administered to him, because he should be able to speak freely and he should be put forth his defense entirely. So right at the beginning of the trial, you must know that what is the offense, what are the ingredients, where am I fitting in this, what is my role, and how I am going to put forth my defense and how I am going to explain my defense. Because if you are not explaining your defense, that case is going to result into a conviction ultimately. And that is why cases of circumstantial, when you have direct eyewitnesses in such cases, you are left with a very small leeway. But when it is a case of circumstantial evidence, you are most probably familiar that when there is a case of circumstantial evidence, the chain must be so perfect that no other hypothesis other than the hypothesis of guilt is possible. So that gives you a chance to play around of what can be the defense for your fact. Also, if there are any law students, I'll also say that as a criminal lawyer, or if you're interested in going into the criminal side of practice, you always have to deal with such aspects and you have to be very careful. That is why a criminal lawyer should be very careful in reading a charge sheet thoroughly. There are medical evidences. In certain cases, I had one case wherein it was a case of rape. The first 3 pages of a medical examination report belong to one lady and the last 3 pages belong to other lady. So these are certain fatal mistakes. Sometimes prosecution can make such mistakes. Maybe the hospital had load. It was a government hospital. So you have to figure out that these reports are not matching. If they are not matching, what may be the reason? And that is why as a criminal lawyer, you must also have ancillary knowledge of all these things. When you read medical report, now these days you have AI. I've seen a lot of students when they submit the assignments to me, they are AI generated. I am not against using AI, but my humble suggestion to you guys will be, see, use AI, but how you use it for your betterment. I'll tell you an example. Suppose if it is a case of a murder, the accused person that you are defending, the allegations are that he had stabbed. Okay. Eyewitnesses say it was a chopper. Charge sheet under section 27 Panchanama is there. So what happens is they commit a murder. They say that he had stabbed. But when the accused person murder, they throw away the knife somewhere, they run away. There is a Panchanama which is carried out, which is known as Nivedan Panchanama. The accused confesses that yes, I committed murder. I threw away the knife on this. Maybe I went on the Bhide pool and I threw away the knife at that point. I disposed it off there over there. That is what is known as recovery and discovery. If you have read evidence law, you know these concepts. So police goes to that spot, and if they find the knife, they say yes, the knife has now been recovered. So the case of the prosecution as per eyewitnesses is उसने चॉपर से मारा. रिकवर क्या होता है? बटन नाइफ रिकवर होता है. Okay, so you have to be aware as a criminal lawyer of the difference between a chopper and what is a button knife. So button knife recover हुआ है तो definitely वो planted है. So how do you bring it on record? So you this time you use AI कि अगर चॉपर से ये एंगल पे इतने फोर्स के साथ में इतने उम्र के आदमी ने इस एंगल से मारा तो कैसा जख्म होगा. You ask AI. AI will give you the answer. अगर बटन नाइफ से मारा तो क्या होगा? AI will give you answer. Then you take these two comparisons, you make this study, and then you go and sit with the doctor who has experience of performing postmortem reports, and then you cross verify with him that this is my probable cross examination, whether I am on the right track or whether I am on the wrong track. Because if you put up your charge sheet, AI will give you 10-20 general questions of cross examination, but you will not make out to be a good lawyer. To be a good lawyer, integrate AI in such a way. Take these two analysis and consult with someone who is expert in that field. You should know what is an occipital region, what is a parietal region of the head, so that you are able to understand what is the nature of injury. Use AI. Sometimes when I do not understand the technical terms in the postmortem report, I scan that thing and I tell AI, ChatGPT, that explain to me like a school going boy, what are these medical terms? Then it explains to me, this is part, this is that. This is how you use AI instead of asking him something directly that give me such and such questions for cross examination. That is a bad way to go around it. Use technology in such a way. Always consult experts in those fields. Now see, what is my assumption? I'll end with this and we will go to question and answers because this is a vast topic. I'm only telling you what I can figure out. When you ask questions, maybe I'll be able to share more of what I have experienced. What is going to happen in future? This is my understanding of how criminal law is going to pan out in future. Right now, the acquittal rate is at an all-time high. The acquittal rate is very high. And that is why right from the legislature to the court, they want to prevent acquittals on frivolous grounds. That is why you have these new 3 criminal laws. And there is a huge incorporation of technology. Conducting a crime these days is not so easy. You have CCTVs. Any offense which has more than 7 years, they are going to take the forensic examiner right at the spot of incident. They are going to do every Panchanama by video recording. Earlier, what was the case? You take 2 independent witnesses, the police take 2 independent witnesses. Those witnesses or those Pancha witnesses are always habitual. What was the standard practice of criminal law? You contact those witnesses, those are habitual. When they come to the court, you offer them money, they turn hostile, nothing is recovered and nothing is admitted. That was the traditional way of practicing criminal law, which I advise against, which is not an honest practice and ethical practice of criminal law. And there is no fun. Personally, I find no fun. If you're going to do this, you're not a criminal lawyer, in my opinion. Now, what is going to happen? Everything is audio and video recorded. Everything is coming with a 65B certificate, now 63 of the Bharatiya Sakshi Adhiniyam. There is a certificate, there is authenticity. Even if the witness turns hostile, the video examination is there. So what is going to happen further in the realm of criminal law is, it is going to be very difficult because of incorporation of technology to have acquittals. The prosecution cases are going to be very tight. So that is why it will be your job as a criminal lawyer to have relevant experience and also to think in multiple dimensions and to take or to consult experts. So when we come to 63 or when you come to forensic analysis, you should be able to have certain person who knows this forensic analysis, make your study, go to that person, verify your cross examination from that person. This is what I believe that criminal law is going to pan up into, and this is what I was able to figure out the number of points that I believe I should have shared with you. If you have any questions, you can ask those questions so that I'll be able to put forth more of my inputs. Yes, Ritesh is there. You can ask the question, Ritesh.
Sir,
Wait, Ritesh, please.
Yeah.
So before starting, we'll just introduce Pale Advocacy
Yeah.
Competition.
You can do that. Then we can start with
Yes.
question and answer.
Mm,
Yeah.
Let me Thank you so much, sir, for such an insightful and thought provoking session. Your practical insights have certainly helped us understand criminal law beyond textbooks and appreciate the realities of criminal litigation. Before we invite the questions from our participants, I have an announcement for the participants. We all learn different facets of criminal law today, so Collective Counsel has brought a platform to implement this knowledge with its National Bail Advocacy Competition. I request Palak to introduce the competition.
Hello, hi everyone. Very good evening to you, Raghav sir. And
Good
thank
evening.
you so much for such a wonderful session. I am so glad and I welcome everyone who is joining us from various different law schools across the country. So just now we heard Raghav sir and we got a brief idea about what criminal litigation is. Okay. But then just because we heard him, I want each one of you to close your eyes and 15 seconds के लिए imagine कि आप लोग कोर्ट रूम 4 में हो. The judge is sitting on the bench. Okay. The opposing counsel is all ready. आपका client आपकी तरफ देख रहा है. And the judge says, counsel for the applicant, you may begin. अब एक honest question. अगर कल आप लोग को सच में एक बेल मैटर आर्ग्यू करना पड़ा, तो आर यू ऑल इवन कॉन्फिडेंट कि हम वो अच्छे से कर पाएंगे? I believe many less people would be confident. Okay, and इसका reason is not कि हमारे पास talent की कमी है, but exposure, and I believe Raghav sir will agree with that. इस वजह से we, the collective council, are bringing ahead the NBAC 2026, which is India's first simulation-based national bail advocacy competition. ये सिर्फ एक competition नहीं है, but this is a complete learning experience for each student. ये एक opportunity है अपने आप को कोर्ट रूम के लिए प्रिपेयर करने की, जब आप अभी भी सिर्फ एक स्टूडेंट ही है. ठीक है, तो सोचिए कि क्लासरूम में हम बैरक्स पढ़ते हैं, जजमेंट्स एनालाइज करते हैं, नोट्स बनाते हैं, एग्जाम्स भी देते हैं, लेकिन जब रियल क्लाइंट सामने आता है तो सिर्फ सेक्शंस याद रखने से बात नहीं होती. वी हैव टू एनालाइज फैक्ट्स. हमें रेलेवेंट प्रोविजंस आइडेंटिफाई करने होते हैं, स्ट्रैटेजी बिल्ड करनी पड़ती है, और जज के सामने अपनी बात बहुत कॉन्फिडेंस से रखनी पड़ती है. और ये स्किल्स ट्रूली सिर्फ एक एडवोकेट ही डिफाइन करता है. So the competition is divided into 3 rounds. I'll first go briefing you all about the round one. So round one एक written bail memorandum round है, which is on the 19th of July, जिसमें we would provide you with an FIR, an arrest memo, medical records and the bank statement summary of the accused, जो एक पूरा realistic criminal case file होगा, बिल्कुल वैसे ही जैसे रियल लीगल प्रैक्टिस में मिलता है. नो हाईलाइटेड फैक्ट्स, नो रेडीमेड आर्ग्यूमेंट्स. ये सब आपको खुद आइडेंटिफाई करना होगा, कौन से फैक्ट्स रेलेवेंट है, कौन से लीगल प्रोविजंस अप्लाई करनी होंगी, और उनके बेसिस पर एक प्रोफेशनल बेल मेमोरेंडम प्रिपेयर करना होगा. इस प्रोसेस में आप सिर्फ ड्राफ्टिंग नहीं करेंगे, बट आप लीगल रीजनिंग, एनालिटिकल थिंकिंग एंड प्रैक्टिकल एप्लीकेशन सीखेंगे. ये सब आपको, दिस इज इम्पोर्टेंट बिकॉज ये सब आपको सिर्फ 48 आवर्स पहले ऑफ राउंड वन दिया जाएगा, विच फोर्सेस यू कि अगर आप लोग को कोई बेल आर्ग्यूमेंट एक दिन में करना है, तो हाउ डू यू मेक द मोस्ट ऑफ योर टाइम. I now request Vineet to go ahead with the round two के details.
Hello everyone, I'm Vineet Pratap Singh, a part of the organizing committee for the NBAC2. Talking about the round. अगर आप क्वालिफाई करते हैं तो अब कागज से कोर्ट रूम की तरफ बढ़ेंगे. आप बेंच के सामने अपनी बेल एप्लीकेशन को आर्ग्यू करने जाएंगे. जजेस आपसे क्वेश्चन पूछ सकते हैं, इंटरप्ट कर सकते हैं, आपसे रीजनिंग मांग सकते हैं, और इसी प्रोसेस में आप कई सारी चीजें सीखेंगे, जैसे कि प्रेशर में सोचना, इंस्टेंट रिस्पॉन्स देना और कॉन्फिडेंस के साथ कोर्ट कम्युनिकेशन करना. ये एक्सपीरियंस बुक से नहीं मिलता, ये मिलता है प्रैक्टिस से. थैंक यू वेरी मच. एंड नाउ additional documents which you will be receiving during the round 2, that will include investigation officer's report, financial investigation report, digital communication dossier and co-accused के statements. Now I will hand over to Anusha. Thank you.
Hello everyone. Good evening, sir. I am Anusha, a part of the co-organizing team, and now I'll be explaining about round 3, ग्रैंड फिनाले. ग्रैंड फिनाले राउंड सिर्फ जीतने के लिए नहीं है. ये राउंड एक प्लेटफॉर्म है जो डेमोन्स्ट्रेट करेगा कि आप लॉ को प्रैक्टिकली कितना समझते हैं. यहाँ पार्टिसिपेंट सिर्फ आर्गुमेंट्स नहीं करेंगे, वो प्रोफेशनलिज्म, लीगल एडवोकेसी एंड रीजनिंग दिखाएंगे, जो कि एक फ्यूचर लिटिगेटर की असली पहचान होती है. इस राउंड में आपको मिलेगा मीडिया कंपाइलेशन, क्रिमिनल एंटीसिडेंट रिपोर्ट, पब्लिक रिप्रेजेंटेशन कंपाइलेशन, supplementary investigation material. All this material will be posted 24 hours before the final round, and the last date to register is 15th of July. Now, the further information will be provided by Sanskriti.
Sanskriti, please unmute yourself.
Hello, so sorry. Am I audible now?
Yes, sir.
Okay. So अगर आप फर्स्ट ईयर लॉ स्टूडेंट है तो ये कंपटीशन आपको प्रैक्टिकल लीगल एक्सपोजर देगा. अगर आप सीनियर स्टूडेंट है तो ये आपको एडवोकेसी और ड्राफ्टिंग स्किल्स को और स्ट्रेंथन करेगा. और अगर आप इंटर्नशिप्स के लिए प्रिपेयर कर रहे हैं तो ये एक्सपीरियंस आपको सीवी और इंटरव्यूज दोनों में वैल्यू ऐड करेगा. हर पार्टिसिपेंट यहाँ से लेकर जाएगा क्रिमिनल लॉ का प्रैक्टिकल एक्सपोजर, बेल मेमोरेंडम ड्राफ्टिंग का रियल एक्सपीरियंस, कोर्टरूम एडवोकेसी का सिमुलेटेड एक्सपीरियंस, एनालिटिकल और लीगल रीजनिंग स्किल्स, कॉन्फिडेंस इन पब्लिक स्पीकिंग एंड लीगल आर्ग्यूमेंट्स, feedback from experienced legal professionals, networking with law students from across India, internship and mentorship opportunities, certificate of participation, और सबसे इम्पोर्टेंट एक प्रैक्टिकल अंडरस्टैंडिंग कि कोर्ट रूम एक्चुअली कैसे काम करता है. इमेजिन किसी इंटर्नशिप इंटरव्यू में आपसे पूछा जाए, डू यू हैव एनी प्रैक्टिकल एक्सपोजर टू क्रिमिनल लॉ, और आप कॉन्फिडेंटली कह सके, यस, आई एनालाइज्ड अ क्रिमिनल केस, drafted a bail memorandum and argued a simulated bail matter before a bench. ये सिर्फ एक आंसर नहीं होगा, ये आपको दूसरे कैंडिडेट से अलग खड़ा करेगा. और अगर आप विनर्स बनते हैं तो ट्रॉफीज, कैश प्राइजेस, सर्टिफिकेट्स, मेंटरशिप अपॉर्चुनिटीज और नेशनल रिकॉग्निशन भी आपका इंतजार कर रहे होंगे. लेकिन सबसे बड़ी अचीवमेंट वो कॉन्फिडेंस होगा जो आपको कोर्टरूम के लिए लेकर जाएंगे. सो मैं एक सिंपल थॉट के साथ कंक्लूड करना चाहती हूँ. आज से 1 साल बाद 2 लॉ स्टूडेंट्स मिलते हैं. एक कहता है, काश मैंने एनबीएससी में पार्टिसिपेट किया होता, और दूसरा कहता है, एनबीएससी was the first time I truly understood what it feels like to think and perform like a criminal lawyer. डिसीजन आज आपके हाथ में है. रजिस्ट्रेशन फी सिर्फ 499 रखी गई है. एक्सपीरियंस की वैल्यू 499 से कहीं ज्यादा है. लेकिन हम चाहते हैं कि प्रैक्टिकल लीगल एजुकेशन हर एस्पायरिंग लॉयर तक पहुंच सके. ये सिर्फ कंपटीशन की रजिस्ट्रेशन नहीं है, ये अपनी एडवोकेसी स्किल्स, कॉन्फिडेंस और लीगल करियर में एक इन्वेस्टमेंट है. Registrations are now open. Competition completely virtual है and open to all law students and recent graduates across India. Challenge yourself, represent your law school, build practical legal skills, और सिर्फ क्रिमिनल लॉ पढ़ने तक खुद को मत सीमित रखिए, उसे अप्लाई भी कीजिए. We'll see you at NBAC 2026. Thank you and all the very best. This version is most student-centric, emphasizes tangible learning outcomes, and repeatedly answers the question every participant has, what's in for me? It feels motivational without sounding like a sales pitch. So the last registration date is 15th July, and we are happy to be looking forward.
We
Thank you.
see you all there. Thank you so much. And I also thank the education department and Raghav sir for letting us to tell the students about the competition.
Thank you so much. Sir, we can proceed with the question and answer session.
Please, any way that you want, if you have decided any order of questions or anything. Or we can start.
Participants can
Yeah.
put their questions in the chat box and we'll take
Correct.
one of the questions.
Yeah. You can
Ritesh, you
also-
want to ask, right? You can
Yes.
ask your.
A very good evening, sir.
Yeah, good evening. Good evening, Ritesh.
सर एक्चुअली जिस तरीके से आज आपने बताया दिस सेशन इज वेरी अमेजिंग दैट्स वेरी वंडरफुल सेशन एंड थैंक यू सो मच फॉर ऑल mentor connect with me in this session, and I'm obviously BLLB student. This year my BA is the last year and next year starting my law, and I'm graduating in Uttarakhand Maharaja Aghat Singh Garhwal Himalayan University. And sir, I ask you question and I'm comfortable in Hindi language. My English.
Yeah. Please go ahead. Please go ahead.
So actually, I watch. मैं रोज न्यूज देखता हूँ तो मुझे सबसे ज्यादा सर अब तो इस एज में सबसे ज्यादा मुझे क्राइम बहुत देखने को मिल रहे हैं हर दिन। कभी किसी स्टेट में कुछ क्राइम हो रहा है, कभी कहीं। एक्चुअली फिलहाल अभी दिस ईयर हुआ था, जो एक लड़का था द्वारका में, साहिल इज गोइंग टू द ऑफिस एंड पीछे से कार आई, उसमें एक ब्रदर सिस्टर थे। इज नॉट फोकस फॉर द ड्राइविंग, ब्रदर इज नॉट फोकस फॉर द ड्राइविंग, ब्रदर एंड सिस्टर is a fun way and make a reels and videos in Snapchat. What are you doing? And this is not, you not following the rules and regulations.
Correct.
And government of India is not take action for this crime, and full on is a criminal opening, मतलब कि खुला घूम रहा है जो क्रिमिनल है, इज नॉट अरेस्ट, पुलिस इज नॉट अरेस्ट, नॉट लीगली एक्शन। तो ये बहुत गलत चीज है। एंड अदर कंट्रीज इज अ वेरी स्ट्रिक्ट लॉज, लाइक एज अ मिडल ईस्ट इज अ मुस्लिम कंट्रीज ऑफ स्ट्रिक्ट लॉ। सर माना जाता है, क्योंकि मेरे से भी कई लोगों ने कहा स्ट्रिक्ट लॉ बनाने से क्राइम खत्म नहीं होगा। दिस इज वेरी, ये सही कहा उन्होंने, क्राइम खत्म नहीं होगा, बट क्राइम पे कंट्रोल होगा। क्योंकि सर जिस तरीके से आज इंडिया में क्राइम बढ़ता जा रहा है दिन पर दिन, हर दिन सर इतने ज्यादा गर्ल्स के साथ डोमेस्टिक वायलेंस, सेक्सुअल हरासमेंट, रेप्स इतने होते हैं। अभी थोड़ी देर पहले मैंने देखा कि राजस्थान में एक गर्ल थी, she is a teenage girl and she is going to the home, but actually जो ऑटो ड्राइवर था he is not dropping home, and उसने उसे होटल पे रोका एंड वहां पे उसके साथ 30 बंदों ने उसके साथ जो दरिंदगी किया, मेरा दिल दहल गया सुन के। आए दिन सर बहुत ज्यादा इंसिडेंट्स बढ़ते जा रहे हैं, इस पे कोई कंट्रोल नहीं है। इसी तरीके से लखनऊ में जो इंसिडेंट्स हुआ था वहाँ पे AI इंस्टीट्यूट में इज blasting the computer, anything is a not good facilities in the institute। मतलब वहाँ पे कोई सुविधा नहीं थी। जिस तरीके से वहाँ पे 15 बच्चों की जान गई एंड 24 cats in the pet shop is over the, बहुत ज्यादा जो हुआ, आई एम नॉट, तो वो चीज है।
Correct. So your concern is the growing rate of crime. See, as I said earlier, जैसा मैंने कहा कि अभी ये जो ट्रेंड है ये शिफ्टिंग ऑफ लॉ का ट्रेंड है. That is why I ended my session from what I was able to gather. Because see, if you see, we can see comments of common people also. See, it is our job as a criminal lawyer.
Yes.
But every time you see comments of common people, there is an enragement in people against such crimes. Now, recently, in 2-3 days back, the court gave death sentence to that case of Nasrapur, where such a little girl only, she was raped and murdered. So it was the need of time. People are absolutely enraged because of such crimes taking place. And that is why I said the law is shifting. What I am reading judgments, the court is more inclined these days. Even the judges that we face, they are not letting off people easily. See, what happens is, usually what used to happen, I'll tell you now, I'll try to reduce my reasonings for this. Usually what used to happen is, earlier all judges used to come after a certain degree of years of practice. So now see, I am a criminal lawyer today. If I become a judge tomorrow, I'll definitely have my all these experiences with me when I am a judge. Now what is happening? After 3 years, you can become a judge, you are becoming a JMFC. So there is more tendency to give a conviction. They are not letting you off easily, first of all. Second is, our investigating agencies are still lacking. This is my another experience. Our investigating agencies are not being given, because I have also given training to some of the police officers, and that is when I go to their sessions, I realize that training is not up to date. So now also government has also started taking certain efforts. So maybe with time and incorporation of technology, as I said, as more and more technology comes in, you will have CCTVs, you will have mobile phones, you have recording of everything, you can track locations, you can have CDR. All these things were not available in 1990s. All these are very recent developments. See, even mobile phone became very common after 2005. So now with the advancement of technology and this three new laws, now what they have done the changes. Earlier, the punishment for causing death by negligence was only 3 years. Now they have also increased the punishment. Now they have made the punishment of 10 years minimum. So this is how they are incorporating changes. So they are taking care of everything. They are uh, making enhancement in the punishments. They are incorporating technology. Judges are being appointed now. If you see the trend, I often tell the students that if you want to become a judge, but if you are a first generation lawyer, the most common way is to become a public prosecutor first. Because if you see, at least in Maharashtra, in Bombay High Court, if you see many judges right now who sit on the criminal side, they're public prosecutors at one point of time. So such changes are coming in, and then we can expect, because people are definitely enraged, and the people in power also have to take note of such things. I see the comments every time a lawyer posts some criminal case, he's representing the accused person. They get a lot of abuses, but at the end of the day, we have to do that thing because it is our job. Maybe in time you will have some better improvements in all these things. All these things are very subjective, but what I see the picture is not perfect, but I see the picture definitely improving in the coming time with advancement of technology and these new laws and how they will play out in its interpretation.
Yes, sir. Make sure new generations make strict laws. First of all, as a law student, make a strict
Correct.
laws and
Correct, correct. That is why I believe that you should all participate in this bail and remand competition, because what I observe usually is that people from law schools are more inclined towards corporate law, or even if they want to come into practice, they directly want to start off at the Supreme Court and High Court. No one is interested in coming into trial court.
obviously, yes, yes.
So the
And
most of the cream
my
goes over there. So if you guys, if you are good students and if you become good
my
lawyers, please come to the trial court so that we will have good justice system also.
yes, my cousin brothers also as a lawyer. So
Yeah.
always I'm joining this session. Palak, she's discussed the webinar session maybe.
Correct.
So I will join.
Yeah,
I'm
yeah.
very excited for the any laws, rules, regulations,
Correct.
and I focus for my law study. So I make sure in the future I India is a strict laws is a announce the strict laws in the country. इससे सर एक्चुअली मैंने ये भी देखा है, जैसा भी आपने बताया, मैंने ये भी देखा कि जो अदर कंट्री से लोग आते हैं वो भी सेफ नहीं होते। हाँ, उनके पीछे मैंने एक बार एक देखा था कि एक बाहर से कोई टूरिस्टर आता है एज अ फीमेल टूरिस्टर, उनके पीछे कुछ बॉयज लोग पीछे जा रहे थे होली फेस्टिवल, उनके साथ बदतमीजी करते। शी इज नॉट कंफर्टेबल एंड एज अ कंफर्टेबल फील इन द कंट्री। वाई वो बहुत ज्यादा गिल्टी फील हो रहा था, उसे गंदा लग रहा था, क्या हो रहा है, मेरे पीछे क्यों आ रहे हैं। वो कुछ उनसे हाल चाल पूछे होंगे और थोड़ा कुछ उन्हें कहीं जारी होगी उस चीज, उन्हें कोई लोकेशन वगैरह पूछे कि जगह कहाँ पे है, या उसने हाल चाल, तो वो बॉयज उसके पीछे चल दिए कि शी इज अ फॉरेनर। तो दिस इज नॉट गुड थिंग कि आप इंडिया में रह के आप यहाँ के सिटीजन को भी नहीं, बाहर के भी आप कोई रिस्पेक्ट नहीं दूसरी कंट्री के लोग। तो सर इससे टूरिज्म पे बैड इफेक्ट पड़ता है कि अदर कंट्री के लोग फिर इंडिया के लिए बहुत ज्यादा वो करेंगे, तो वो चीज भी गलत है। बट इंडिया इज अ वेरी हेल्पिंग नेचर। अभी जो अर्थक्वेक आया था वेनेजुएला में, इंडिया इज अ वेरी हेल्पिंग नेचर, सो वो तो है। बट लेकिन जो लॉज हैं वो थोड़े सारे यहाँ के ठीक नहीं है, थोड़े स्ट्रिक्ट लॉज होने चाहिए। अभी मोदी जी ने भी भारतीय न्याय सहित लागू किए थे अभी, तो उससे भी सर कोई क्रिमिनल्स के ऊपर कोई वो नहीं है कि जैसे उसमें थोड़ा
with time we will see these effects. Right now these laws are very new. With time maybe we will see these effects, but I get your point, Ritesh, and I admire your aspirations. Yeah, thank you Ritesh.
Thank you for your question. We have Vineet who wants to ask something.
Yeah, so I had a very simple question. Ki sir, as you recommended, ki like you become a public prosecutor first, and then you can go on to become a judges
If you
in
are
the
a first
Bombay High
generation lawyer, fortunately or
Yes.
unfortunately.
yes. So I just had a one question that like
Yeah.
for the conditions for the becoming of additional district judge or the judge of the high court, etc. So there
Correct.
is a specific condition which says that you must have at least a 10-year of standing at the bar.
Yes,
Okay.
yes.
So
Yeah.
whatever you are suggesting that the public prosecutor thing,
It takes you at least 7 years. The practice criteria for public prosecutor is at least 7 years of practice. And I'm sorry, but
7 years for additional district judge.
yeah, for additional district judge also, for even being appointed as special public prosecutor also, or even for being as an assistant public prosecutor before the magistrates court, 7 years of practice is compulsory.
Okay. So
Yeah, and
for the judges becoming a judge, so APO का what I was asking is कि APO जो है for our Rajasthan, so there is a direct vacancy. Okay, without any experience, just the LLB is required. So I'm just saying कि एक वो person जो government job का है, तो is that experience gonna be counting वो जब judge बनते
no,
हैं
no, no, it
like
will not
high
count.
court
It will
में?
not count. It is the standing of the bar. You need a certificate from that particular bar association that this person is practicing at our bar from this and this year.
अच्छा.
That you have to submit.
Okay, so for the public prosecutors which have been appointed by the government, so they are not the government employees as such, which you
They
were
are
suggesting.
public servants. They are public servants. There is a difference. They are public servants. So that is they get their remuneration and everything from the government.
Okay, but
But
they
they
are
are
not the
appointed by
permanent.
MPSC only. Like in Maharashtra, they are appointed by MPSC only. Maharashtra government has taken the decision that we will conduct an examination and MPSC will appoint. So that is how it is governed. Sometimes it might differ from state to state, but usually Public Service Commission exams only are the ones those authorities take these examinations.
So I just so like just to clarify this thing. So how come your example from the first being a public prosecutor or the high court judge? So how that
No, so what
travel
happens
on?
is usually I'll tell you. Now there are many aspects to this, but this is the trend that I've seen at the Bombay High Court recently. That you become a public prosecutor, then thereafter you get elevated as the public prosecutor at the High Court, and then they can offer you a judgeship. So you get offer a judgeship. So they are like, okay, this person is good at criminal law. And usually say, I'll tell you, I'll be very frank. Usually what happens is public prosecutors, if you are directly appointed, there is an appointment of public prosecutor directly also. Special public prosecutors, they are known. You do not have to give exam. So स्पेशल पब्लिक प्रोसिक्यूटर यूजुअली उसी गवर्नमेंट का होता है और उसी आइडियोलॉजी का होता है जिस गवर्नमेंट की सरकार है, और उस गवर्नमेंट की सरकार को वही जजेस चाहिए होते हैं जो उनके आइडियोलॉजी के हैं. दिस इज अ रियल फैक्ट एंड दिस हैज बीन डन बाय एवरी गवर्नमेंट एंड एवरी पॉलिटिकल पार्टी. दैट इज व्हाई व्हेन यू आर पब्लिक प्रोसिक्यूटर यू गेट एलिवेटेड एज अ जज. दैट इज द रियलिटी ऑफ इट.
Yeah, I now got your point clearly.
Yes.
Thank you, sir. We have one more question from Palak. What are some common mistakes that young advocates make during their initial years of criminal practice, particularly while handling clients, drafting, or appearing before the courts?
The first mistake I often say is that they do not come out of your college life, because even after joining a chamber, they are like, today I have to go with my friends over here, today there, after tomorrow I have to go there. That is the first mistake that you make, because when you are not coming to the chamber, the people at the chamber are already practicing. Like my senior has 35 years of experience. I am not even 35 years old. So he's not missing out on anything. It is you who are missing out on having those opportunities. So if you are not present at the chamber, you are going to miss out the opportunity to work on good cases. That is the first thing. Second is that when you are drafting, I believe is that lot of people, which I am noticing, lot of people cannot draft on their own. And this AI is making things worse. They are giving AI drafted drafts to us also while they are submitting. So be in the habit of drafting. If you are not able to put up your thoughts on paper, how will you put up your thoughts when you are arguing before the court? So you must be very good at drafting. See, initially it is not the case that everyone is very perfect at drafting, but you should be able to draft the basic facts. What is the case of prosecution? What are the grounds for bail? At least incorporate all those things. The third thing is that even if you are not seeing material progress on a great level, you have to have patience in this profession. There is no other alternative for patience. If you are a first generation lawyer, of course. If you are someone coming from a family of lawyers, maybe you have an easy way. Maybe you get cases earlier in life, but you should have a patience. Most of the times what I see is they start coming to the now every year. Now this is the month of June, July. So now colleges have not started and some have just ended their final year. So in June, July, we see a lot of people coming to the court. But by the month of November, December, half of them disappear because they think that the moment we are entering the court, there will be red carpet for us and we will be arguing like they show in movies and we will be making arguments. See, you're a young lawyer, no one is going to hire you. The initial days you are going to get, even though if you are practicing on criminal side, you are going to get succession certificate, heirship certificate, return of property applications, making a will for someone. These are the initial jobs that you get, going to some police station. So you have to put up with that. It is after that you get a recognition, you start getting cases and people start feeling, even the judges are also, as a junior lawyer, when you appear, the judges are not very keen to listen to you, except the high court. This is not what I'm talking about. I'm talking about trial courts. At the high court, judges are more encouraging. At the trial courts, I've observed they are not inclined to listen to you. So these are the problems. So you have to have patience. You have to work hard. You have to be present in the chamber and get out of your college life very quickly. Understand the fact, do not avoid responsibility. Understand the fact that 5 साल का holiday package खत्म हो गया है. Now you have to get down to work. And then if you avoid these mistakes, then maybe and figure out what you want to do. My one more thing is, you ask what mistakes lawyers do. I often tend to tell lawyers that take 5 year, of course, 5 year students have more opportunity. Do a lot of internships. So do one internship at trial court, do one internship at high court. If you are able to secure something at Supreme Court, do over there. Go into corporate law, go into a PPO or another company or a legal department of a bank, see what job in-house counsel does. So once you have experienced 6-7 things, then choose one. Because for me, unfortunately, it so happened that 1.5 years went away in COVID. So I had no chance. So when I graduated also, it was directly, when I was going to the court, even the courts were functioning only for 4 hours due to COVID restrictions. So there was no choice with me but to start practicing in Pune. But you guys have an opportunity, so explore things and then you will be able to make a good choice.
A follow-up on that,
Yeah.
for students who aspire to practice criminal law, what
Hmm.
steps would you recommend during their internships or when they are still in law schools so that
Hmm.
they can get those meaningful courtroom exposures, as you have mentioned?
See, criminal law, I'll tell you very clearly, criminal law does not require any prior preparation as such. You learn the procedure. Criminal law is more about procedure and technicalities. So you are going to learn the procedure anyway when you start going to the court. What I would suggest is, when you are a student, search for a chamber where you have access. Search for a chamber, because I often listen to students who say that we do not even get to touch a file or we do not even get to read a file. So avoid going to such chamber. See where a particular senior is keen on guiding you. So if you go to such a chamber, then maybe you will be there and make a decision whether you are good at taking cross examination. Because see, sometimes some people are not good at English communication और they are not very good at forming arguments, तो उनके लिए हाई कोर्ट का प्रैक्टिस बना नहीं है. सो ऐसे लोगों ने ट्रायल कोर्ट में जाना चाहिए. दे आर ब्रिलियंट क्रॉस एग्जामिनर्स and in trial court you can even do it in Marathi or whichever state you come from. So you need to identify the student whether you are good at cross examination or whether you are good at arguments. If you are creative in creating arguments, if your interpretation is good, if you are interested in constitutional law, then definitely go to the high court. अगर आपको क्रॉस लेने में ज्यादा मजा आता है, if you are habitual of doing the groundwork, if you are interested in doing the groundwork, then trial courts में जाओ.
Thank you, sir. Follow up on that. You said that criminal procedures are most important. What
Correct.
procedures would you suggest that a criminal lawyer should know only? Like, there is like non-negotiable procedures which you have to do.
See, the first thing is that, of course, chief and cross are the most important. The secondly, you should know is that how CRPC operates, how an FIR is registered, what are the particulars, what is a confession, what is a statement, what is the difference between confession and statement, what is a test identification parade, because every case has certain elements which are different. How a statement is recorded by magistrate, how a statement is recorded by police, what is omission, improvement, and contradiction. Of course, these are practical aspects, but you have to know the theory also, and you have to see these things, go in the court and see how these things govern. So when you understand how a charge is framed, how discharge application operates, so there are the entire trial from the registration of FIR to judgment. Everything is important, and even after judgment, there are certain things like appeals and staying of execution of sentence. All these things are there, so you get it on the go as more and more cases. So that is why I say finding a good senior is very good thing. because if he's an experienced person, you get to experience number of cases. So if you get to experience number of cases, you get to know different aspects, और तुम जल्दी सीखते हो in comparison to people who are maybe not so fortunate to be at a good chair.
Thank you so much, sir. I'm so sorry. We are really at the end of the time, so
Correct.
we cannot take more questions. As we come to end of today's session, I would like to express a sincere gratitude to Advocate Raghav Puranik sir for taking the time to share his knowledge, professional experience, and practical insights into this field of criminal law. Your guidance has helped us all gain a deeper application of criminal litigation and has provided valuable direction to students who aspire to pursue the same. On behalf of the Collective Council, we sincerely thank you for your valuable time and for inspiring interaction with our participants.
Yeah.
Before everyone leaves, kindly fill the feedback form which is circulated in the chat box. And before we conclude, let's capture this wonderful evening with a virtual group photograph. Kindly switch on your cameras.
I also thank everyone for listening to me patiently, and also the Collective Council for inviting me here today. Thank you.
Thank you. Thank you, sir.
Thank you, sir.
I hope everyone has switched on their cameras.
Sir,
Let's take the screenshot. The feedback form is circulated. Kindly fill it. And thank you everyone for joining us today and making the session interactive and engaging. We look forward to welcoming you again at the future sessions organized by the Collective Council. Thank you, sir. Thank you, everyone.
Thank you.
And goodbye.
Thank